Ladies and gentlemen, welcome. This is William Keat of lawandalchemy.org and commonlawconstitution.org. Okay, so this is a video called Leveson at a Glance, and it's looking at the implications of the Leveson Review proposals that are being proposed by Sir Brian Leveson. Now, I've said this before, these proposals are becoming increasingly likely to go ahead the less that the general public focuses on them and shines a spotlight on them, and the less that there is moral outrage. The less noise there is, the more likely this is going to happen. And my feeling, actually, and I've said this, is that I think that the legislation probably is already drawn up. But nevertheless, I'm going to give you a bit of an outline as to what the main proposals are. This is a bit of a summary. And this video is introducing a downloadable document, which is it's still a summary, but it's a little bit more detailed than this video, of what is being proposed, the main things. Huge thanks to LW, one of our contributors, who's put that together. So this video is really just signposting that document and explaining some of the most sort of eyebrow-raising proposed changes, if you like. So let's just show you that document now, very quickly. Okay, so here it is. Common Law, Constitution, Law and Alchemy, Leveson at a Glance. A brief summary of the major recommendations of Sir Brian Leveson's review of the criminal justice system. So this is it. It's not that long. It's only 4 pages, but it's basically, we've had to. It's a massive document, by the way. Sir Brian's Part 1 review document to anyone who's actually read it. So we've read it through pretty swiftly, but we've pulled out sort of some of the most important observations there. So this is the document. Definitely do download it because it'll give you more detail than this video is going to give you. But as I say, I'm going to give you some key points as a breakdown even of this document in this video as well. So what are we finding? What are our findings? Well, the most obvious thing is it's becoming evident that it will be extremely difficult to reach a jury trial if these proposals go through. Currently, obtaining a jury trial is difficult enough, even in our current system, because as many of you know, only 1% of cases actually reaches a jury currently. But it's interesting that Sir Brian Leveson actually uses that argument for justifying a further reduction. Okay, and this part is actually going to be a second part to this video, which is going to go more into the sort of disingenuous and slightly slippery arguments that he is using in order to justify these proposals. But briefly for now, one of the main themes of those disingenuous arguments is this idea that we're going to use the already degraded state of our justice system, which, remember, that they caused unlawfully and unconstitutionally, to then further justify doing more damage, right? So it's the idea of the slippery slope. Yeah. Now, in order to demonstrate the sort of contrast and the difference between how things are now and how things are going to be, I'm going to go through how the procedures of justice work currently, just briefly. I mean, not in a massive way. And I've got a diagram of the current procedures of justice in the courts, and another one for the proposals as well, so that you can see the difference. So the current situation needs to be explained because there are huge numbers of people who don't currently understand, when you have to go to court, what are the kinds of justice that you get, the fact that it's pre-categorized and determined for you, and that in itself breaches constitutional law. And the main purpose, of course, is for explaining how it works currently so that you can really see the full contrast of how things might work or not if the new proposals are actually implemented in Sir Brian's brave new justice world. So let's have a look at the diagrams. Okay, so I've just put literally just 2 or 3 slides together, actually. So Leveson at a glance, a summary and brief explanation of part 1 of the independent review of the criminal courts. And I'm going to leave it in non-presentation mode so that I can click on things as well, because and let's make it a little bit bigger so that we can really focus in on what's going on. So I can actually select things and sort of show you what I'm talking about. Okay, so this is the way things are at the moment, the current procedure. Okay, and you can see that we've got essentially three types of offence that they've categorised. You've got you've got summary only. I'm just looking down at my notes as well, actually, because I've only got one screen, so I'm having to look down. That doesn't matter because you're only seeing a thumbnail of me anyway. So we've got summary only offence. We've got which is magistrates ending up in the magistrates court for the actual trial. You've then got either way offence, which is where you at the moment have a choice. As the defendant, you can elect to a Crown Court, which is a jury trial at the moment, or you can go to magistrates. A little bit more on that in a moment, actually. And you've got indictable only offence, which is supposedly serious enough that they've deemed to be serious enough that actually you can only have a Crown Court, a jury trial for that. And if you have a magistrate summary only trial, then you are judged by three magistrates and or one district judge, because they sometimes substitute out the magistrates for a district judge. That's important to understand that. And in the Crown Court, you have a jury of 12, and I've written there, but directed by a judge, because keep in mind, of course, that the jury trial that we have in place now is very different from the jury trial that you would have got if the Constitution was operating authentically, because you've got all sorts of watered down effects of that. But the most important being that the juries, of course, are not told of their right to make a decision independently using their conscience, and of course they're told that they're supposed to follow the directions of the judge, and there are some other things too, of course, but that's enough for now, just as a quick reminder. So, what is quite interesting, this is not good, but at least at the moment, there is an election opportunity here in the either way offences for some situations. And that if you do elect trial by jury, you know that you're going to get it. Yeah, okay, that's a that's a hint at where I'm going with this in the moment. So now let's look at the. Oh, before I do, let's talk about this important issue here, because if you choose a jury trial, a Crown Court, you're electing that. If that's the language that's written into the procedures. That's you're making an election. But what is particularly revealing is the language that's used that if you choose to just go along with the magistrates' court, that is a consent. Yeah, so in effect, what you're doing is that you're consenting to a lesser procedure of justice, which is quite revealing. That's an indication that that this is the default route. This is how it should be. Yeah, it's a little bit of a hint there. Yeah, but actually, you're consenting to yeah, I'm happy to have something lesser. You're throwing something away that you have a right to, right? And that's quite interesting. That's quite a little hint there of how it should be. But let's go on to the how things are looking in the proposed in the proposals. If this all goes ahead, this is what's going to happen. Now, we have more either way offences are going to be categorised to summary only. Okay, so you'll see that we have actually four types of offence here. But more offences are going to be categorised now into summary only, which means that more offences are going to be held straight away for certain in the magistrates' court. Yeah, and that's where it goes to the magistrates' court. That's the same. Yeah, and again, three magistrates or one district judge judging you. Yeah, so that's the first thing. I've got written here actually persuasion to plead guilty in the form of sort of credit. Okay, this is a little bit like what probably quite possibly happened with the Lucy Connolly case, which is why the system is set up in such a way that it gives you credit for pleading guilty. Yeah, and so there's a kind of weighting in that way. But this is going to be increased to up to 40% in less in sentence. Yeah, so that's there's going to be quite a weighting there towards sort of persuading you to kind of plead guilty. That's another thing that I just thought I'd flag up there. But all of this is written in more detail in the document. So either way, where the maximum sentence is less than 2 years, you can see I've written that maximum sentence is less than 2 years. This is not a proper either way offence anymore, a proper either way election. because whilst your trial could technically go either way, as in it will end up, could be in the magistrates or it could end up in the Crown Court, it's not your decision anymore as a defendant. Yeah, for these offences, for this second kind of category of offences, it's not your choice. Okay, and this is what they've called, it's what Brian's called restricted right to elect, RRTE. And as LW says in the document, suggests that perhaps we should call it removal of the right to elect would be a more accurate description. Yeah, so it's a bit slippery to call it either way because it's not either way in the sense that you can decide in this category anymore. So that's a bit of a bombshell, even in itself. Yeah, so that's going to be the decision of the magistrate at that point. Now, it's worth mentioning, and LW makes this point, that this is created as an emergency situation because of the backlog in the courts. Yeah, and so Sir Brian is suggesting that in order to put this situation back to how it should be, or should be, doesn't say how it should be, but how it might be now, you would need primary legislation to put this into place, but with a schedule so that it could be easily reversed if slash when the emergency is over. I wonder if that will ever be the case, but anyway, that's just an interesting point. Now, the next category is either way, but in the sense that it is now. So this is still the decision of the defendant. But when do you get that decision? This category is to do with the maximum sentence is 2 years or above. Yeah, so if the maximum sentence for this offence is 2 years or above, then you still get a say in whether you want to elect Crown Court or you consent to the magistrates. Okay. So I've just said, yeah, so just reading off here, either way, where it is still the defendant's decision, it's not much of a decision, right? Now, why? Because of two things, right? If you wanted magistrates, that is a summary trial, you don't know at this stage of the decision whether the magistrate themselves would accept your case in the magistrate's jurisdiction. Because it's their decision as well. They might actually say, no, this needs to go to the Crown Court anyway because of something in it that's serious enough or whatever. Now, also, it's you don't know at this stage whether even if you choose Crown Court, that you would actually even get a jury trial. So previously, as it operates currently, you do know that if you choose Crown Court, then you'll get a jury trial, but not if these proposals were implemented. Yeah, why is that the case? Because this point here is another decision point, this time for the judge in the Crown Court, as to whether your case goes before a new kind of court down here, okay, which Brian has called the Crown Court Bench Division, CCBD, in which you are tried by a judge and two magistrates. So in the Crown Court, you have a court that many cases will be funneled towards, that actually, to all intents and purposes, is really more like a magistrate's court. And many of the cases are going to end up down here. So even if you're making an election back here to go to Crown Court, that doesn't mean anymore that you're going to get a jury necessarily. So you're pretty blind in this point, really. Now, the Criminal Bar Association, interestingly, points out that the proposed new court, this is, I'm quoting now, the proposed new court is in form a Crown Court, but in substance a magistrate's court. Now that's quite interesting. So that's people in the legal profession actually being honest and saying, and in fact, actually, there's more outrage in the legal profession than there is in the freedom movement over this. They don't like it. Yeah, there are many people in the legal profession that are already kicking off about this. Yeah, and so that's important. You know, lawyers don't like this either, and there's a lot, quite a bit of resistance from from them, more than the freedom movement. People who hurl abuse at lawyers need to understand that the situation is more complex, and that they have to work within the framework that they're given. So yes, they should resist those changes, these unconstitutional changes, quite right, within the system. Yeah, but right now they are resisting more than the freedom movement is. Yeah, you need to get honest and real about this. So that's quite an important point. that people in the legal profession don't like these proposals, many of them anyway. So that's an important point. So this is pretty bad because you're pretty blind when you're making this decision at this point. Yeah. Um, Now, I could go further down the document, but I'm not going to at this stage. So the document talks about the appeals process as well. I haven't in this video gone into this one. Indictable only is for more serious offences, which they categorise, of course. That goes to a Crown Court decision by a judge who is probably most likely to go and choose a Crown Court with a jury court at this point here. Um, but there's a possibility that a new situation which has been proposed could end up there with, which is a trial in the Crown Court, but with a judge only. Yeah. And there are two situations where that could be. It's either where they've claimed that, oh, the subject matter is too complex for the jury, which is absurd because they're kind of relying on this rather false argument that juries don't understand complex information, which has been proved through academic research is not the case. Yeah, juries actually are very good at understanding complex information, and the expert witnesses have to be able to present it anyway to court, to the lawyers and to the judge, who also are not experts necessarily in that subject area. So it still has to be presented really clearly. So the idea that juries can't understand complex information has been disproved. It's absurd, that claim, and yet this is based on that idea or partially anyway, that judges can't understand complex information. Not necessarily the case. So there's more to this in the document. Definitely download it and have a look. But you've got stuff about the appeals process. Um, but just as a general point, I mean, just look at this diagram. Yeah, I wanted to make that point actually. It looks like a board game, right? In which you throw dice. Where are you going to end up? If you throw a six, you go this way. If you go, this is really all about cheapening the process of justice because it's playing a game, right? At every point, you're gambling. What are the odds? If I choose this path, is it better if I just plead guilty, or is it better if I go to to elect Crown Court in this situation? We don't really know. Um, so in that situation, then I would say that you're denying the process of justice to discover that in fact you're not guilty and there is no crime. Perhaps you would never have perhaps even been convicted, perhaps, but you've been tempted to plead guilty because you don't want to take the risk. Yeah, it's all about factoring in risk. Yeah, we've got this. We've got it already going on in the current system. But it's going to be a lot worse in this proposed system because at many points you're really blind anyway as to what is the best decision to make. And the other point, of course, is that wherever you've got these decision points, you might need to appeal them anyway. So actually, is this more efficient? Far from it, I would argue. It's far more complex, and it's going to create massive time problems, I would say, on the courts of its own, just of a different kind. So I think this is quite concerning, but do download that document. Let me stop sharing so that you can see me again. But I hope you found that interesting and useful. Definitely in the description of this video, download that document. The link is in there. And it's in the actual location is in the resources area of Common Law Constitution. Get in there and have a look. But I hope you found that interesting and useful. Cheers for now.